Hello everyone, and welcome to today's video. My name is Melanie Martin. I am the Director of Dental Hygiene Practice for CDHA, and I'm delighted to be your host moderator for today's discussion. Thank you very much for joining us. I'm here today with Andrew McKenna, partner in Gowling WLG's Ottawa office. Andrew's practice focuses on medical defense litigation and health law. As counsel for healthcare professionals in both civil and regulatory matters, he has appeared in all levels of court in Ontario, as well as in discipline committee matters, hospital board proceedings, and before various other administrative tribunals. Gowling continues to work closely with its various partners and stakeholders, including CDHA, particularly during the time to bring members information in relation to COVID-19. We have come together today to discuss professional liability and legal considerations. Andrew will provide an introduction followed by a series of questions and answers. Hi, Andrew. Thank you for joining us today.
Thanks, Melanie. As you mentioned, I'm a partner at Gowling's, and we provide legal assistance to members of the CDHA through your insurer. In light of the rapidly evolving nature of the situation we're dealing with, it's important that you all make efforts to try and keep up to date with the latest developments. I appreciate there's a lot of information out there, and there seems to be changing information on a daily basis. And it's important that you try your best to keep up to date. We have been, to the best we can, monitoring the websites of the various colleges across the country, as well as any directions or directives coming from the various ministries. And for the most part, those have all been very helpful. I also would encourage everybody to look at the website of the association, as there is helpful information as well, including the webinar we're doing today. I'm going to answer some questions today in the time that we have, but I appreciate that it probably won't be all the information you may be looking for. And if that's the case, then I would encourage you to please call the pro bono hotline that Gowling's runs. We are able to answer any questions with respect to professional liability. Now, unfortunately, that doesn't cover employment issues or insurance coverage issues, i.e., does my insurance cover this or not cover this? If you have insurance coverage issues, you can go right to your broker, BMS. And if you have employment questions, then there are other services out there, but we can handle any professional liability questions you have. And our lawyers are able and ready to assist you regardless of the jurisdiction you're in. So with that short statement, I think it's probably good that we get to the questions, and then I can expand on the various issues that are pressing.
Great, thank you very much, Andrew. Our first question is, if I continue to be part of the oral health team that provides emergency dental care to clients, are there any liability issues or legalities that I should consider?
Thanks, Melanie. I'm going to answer this question in two parts. The first part being that the same legalities and liability issues apply here regardless of whether you're providing care in an emergency situation or in a regular situation. So just because we are in an emergency situation does not justify cutting corners or not following the guidelines and the standards that are expected of you. You cannot expect your regulator to be more flexible or turn a blind eye to things that you might think of doing because of the nature of the situation. So my advice to you is to ensure that you follow the guidelines and standards that are in place for the provision of care to your client. And keep in mind that you are subject to the jurisdiction of your regulator. You are a registered healthcare professional, and even though you're working in a team environment, or most of you would be with other regulated health professions, you are still going to be expected to comply with the guidelines that are applicable to you. And if there is a conflict or an issue that arises between you and another regulated healthcare professional, then your regulator is going to want to ensure that you are following the steps that you should be as a registered dental hygienist. The second part of my answer is with respect to the extra things you should be doing or taking into account as a result of the situation we're in. There are numerous directives that have been issued by the government. In Ontario, for example, we're now under a declaration of an emergency, and therefore certain directives have been issued. Your regulators have issued directives. You should be aware of all of those and ensuring that you are following those. Simple examples would be making sure you have the appropriate screening in place for people that are sick, the steps that you need to take to mitigate against the risk of the spread of infection, and those sorts of things. So in addition to what you would normally provide to the patient, anything else that applies because of the situation we're in. If you are found not to have taken those directives into account when providing care, then you're opening yourself up to a potential complaint to your regulator down the road. And then the final advice is to make sure you have made inquiries with your insurer to ensure that your coverage is up to date and current. Thanks, Mel.
Great, thank you. The next question is there anything a dental hygienist can do right now to proactively plan for their return to work once it's been declared safe to do so?
Thank you. That's a great question. So I've already touched on some things you can do, which is to make sure you're up to date with the current directives and guidelines from the government and from your colleges. I expect that as we get closer to the time period where a return to work is contemplated, there's going to be guidelines and directives coming out that provide us with some guidance as to what we should be doing. However, I would also recommend that you take the time to think about the infection control protocols you have in place in your office, or the cleaning protocols you have in place in your office, to determine whether there's any shortcomings that can be remedied when we do get back to being able to work. I expect that one of the things that's going to happen as a result of all of this is that the public in general is going to have a greater expectation of all of us that are offering services, that we have taken the appropriate steps to ensure that we're mitigating against the risk of the spread of any type of virus, and we're keeping our workplaces clean. And I expect that expectation is going to be much more enhanced than it is now. So it may be what you have in place meets the standards now, but it may not once we get back. So you may want to be giving some thought as to what else you can do in your office or your workplace environment to either maintain or bring up the standards you have in place. I know the colleges across the country have been vigilant in making sure that dental hygienists have the proper infection control and sterilization processes in place. I have every expectation that that's going to be enhanced as well once we get back to a return to work. So in terms of what you can do right now, obviously it's limited because you're not working, or many people aren't working, and we can't get into our workplaces, but these are things that you should think about so that when you do get back to work, you can hit the ground running.
Great, thank you. The next question is, if a dental hygienist continued to work when the recommendation to stop elective treatment came out, what could happen if someone makes a claim that they were infected during this time?
Okay, that's another very good question. So the structure that's in place would be the same. When I say the structure, either the complaints process with the college or your liability with respect to a civil action are still there. I'll talk about a potential college complaint first. So if you did continue to provide treatment after recommendation was made, and somebody says they got infected, then obviously you're exposed to a potential complaint to your college. I anticipate the college would look at the complaint and want to know what you had in place to mitigate against the spread of an infection. So the things the college would be looking for are what kind of services did you provide after the direction and recommendations. In Ontario, for example, the Ministry of Health has now issued its guidance as to what non-essential and elective procedures are. and what constitutes emergency procedures. So you want to look at those and make sure you've taken that into account. Does what you offer or what you were offering at the time fall under the exceptions? Did you have informed consent from the client about the fact that these services were being provided after the recommendations or the directives were made? So have you had a fulsome discussion with your client about this? What steps did you have in place to make sure that your workplace was clean and sterilized? What protocols did you have in place? Can you point the college to that when, if a complaint does come? The issue about whether the patient actually contracted the virus as a result of interacting with you will not be as important to your college as what steps you had in place to ensure you were in compliance with the guidelines. Keep in mind, the college is tasked with ensuring protection of the public, and that means ensuring that its members are following the guidelines and standards in place. So even if the patient can't prove definitively that they obtained the infection as a result of interacting with you, that's not going to be the primary concern of your college. It will be, did you follow all of the things that you should have in light of the recommendations that were made? And then obviously the college has the ability to impose sanctions upon you, either through the discipline process or through other processes if they determine that you weren't in compliance with the guidelines. A lawsuit would be different in that the patient would be claiming damages, so they would in fact have to be able to prove that the infection was obtained as a result of interaction with you. At this stage, I don't know how hard that would be to prove, but that would be a key element. How all the steps I just went through, though, in terms of what the college would be looking for, would be things that you would have to look at in terms of defending yourself against any lawsuit. So again, ensuring that you had all of these steps and processes in place will help you defend against a claim that you were negligent. So you are open to that, those types of actions if you keep working, but there's no elevated risk of a college complaint or a lawsuit. It's just there's other things that they're going to be looking at if in fact you are faced with one of those processes.
Okay. Great, thank you. About the next steps. So if one of my clients reported testing positive immediately after my office closed, what steps, if any, should I be taking now? Okay.
So the first advice I would give to you is that you really need to call a lawyer and get some legal assistance in terms of developing a plan as to how to deal with it. I can provide some general advice here, but I think it's going to be very fact specific in terms of what steps, in addition to what I'm going to talk about today, are necessary. So if you find yourself in that situation, this does warrant reaching out and asking for assistance. Generally, I would say that the following steps would need to be considered and likely implemented. You would obviously need to be able to identify when the client was in your office or in your workplace. Identify what other individuals were in the office at the time that the client was there, and then identify how long the office was open from the time that client was there until you closed. Once you have that information in place, you then need to determine if you did have a cleaning protocol at that time, when the first time that cleaning protocol was implemented after the client who tested positive was there. So the client's there at 3 in the afternoon and you had a protocol to do a deep cleaning of the office that night or the next morning, that information is going to be important. Once you've figured all that information out, then I believe the likely step you're going to have to take is to reach out to those individuals that you can identify as having been in the office. Keep in mind, your obligation is to ensure the safety and protection of your patients, and that includes a situation where they may have been exposed to this virus, and it's not something you had any control over. It's simply what happened. So you need to be open and communicate that to those individuals best you can. It may be that there may be people that came to the office, you know, a courier coming in, etc., that you're not going to be able to determine, but you need to make those best efforts. And I would imagine you're also going to need to contact your local health unit in order for them to have a basis or an understanding as to where the spread, there may be another spread. So those are just general things you should be thinking about if in fact you find that yourself in that situation. But as I said at the outset, you really should be calling for assistance from a lawyer to help you navigate this situation, because there may be other things you also need to take into account.
Okay, great, thank you. Our last question for today is, what preventive action should a dental hygienist take to avoid legal problems if a client retroactively files a complaint against them?
Okay, thank you. So we are in the business is obviously dealing with complaints when they're made, but we also try to give our clients and our members advice to help prevent complaints. So the steps I'm going to tell you about are steps that you should be taking generally. You can never avoid a complaint. There's nothing you can do to absolutely guarantee you won't get a complaint. The best you can do is take steps to mitigate that risk. So 3 things I would recommend. The first is, and I've already touched on this a couple of times, stay up to date with the directives and guidelines from your regulator. As I said, I appreciate there's lots of information circulating right now. Your best starting point is to go to your provincial regulator and go to the association for any steps that are being recommended. If you do have a complaint made against you, your regulator is going to be looking to make sure that you were aware of the regulations and you were taking steps to ensure compliance with those regulations and guidelines. The second piece of advice is that you need to keep or maintain open and transparent communication with your clients. You would be amazed how many files we see in our office, not only with dental hygienists, but all other healthcare professionals, where the root cause of the complaint was a breakdown in communication. Your clients will appreciate open and transparent communication, and in this environment, they expect it. They want to know what you're doing to ensure that their health is protected. So be transparent, be open, and let your clients know what you're doing to put their health at the forefront. And obviously not doing too much that you're breaching personal health information and privacy. And lastly is document everything. For a lawyer, paper or a documentary trail is always your best friend. And you want to make sure that if you do something or you say something, you've got a paper trail or something you can go back to point to if a problem arises down the line. If you put special measures in place, then make sure that's documented. If you have a consent discussion with a client, make sure it's documented and make sure it's done contemporaneously, meaning done at the time or immediately right after the conversation with the client. If there's an incident, document it. And if there's an incident or you have a question, feel free to seek out advice. Call the pro bono hotline or seek out advice as to how best to handle it. But if you have a documentary record of anything that's occurred, then that puts you in a good position to be able to defend yourself if there is a complaint down the road.
Thank you for answering our pressing questions, Andrew. Do you have any closing remarks?
No, other than to again highlight for you that we appreciate the situation is evolving, and you're going to have questions, and that's great. If you do have questions, we want to hear from you if you do have questions. So please utilize the resources you have available to you, and contact us if there's anything that you need guidance with. And if we can't help you, if it's something outside the scope, then we'll do our best to point you in the right direction as to where you can get that advice. And otherwise, I hope everybody stays healthy and safe.
On behalf of CDHA, I would like to thank Andrew for joining us today. CDHA continues to actively review and assess relevant information for dental hygienists as it relates to the coronavirus pandemic. Please visit cdha.ca/safetyalerts, where you will find updates and information for dental hygienists. Please email your questions to alerts@cdha.ca and indicate video question within the subject line. We will collect your questions until April 3rd and provide responses as soon as possible. Please be well and take care of yourselves in this difficult